All right.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Susan Garsh, Justice of the Superior Court, now sitting at Fall River, within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Good morning. This court is now in session. You may be seated.
Commonwealth versus Aaron Hernandez, indictment 1373 CR 0983. Counsel, would you identify yourself for the record, please?
Good morning, Your Honor. William McCauley and Patrick Bomber, Assistant District Attorneys on behalf of the Commonwealth.
Good morning.
Good morning, Judge Garsh. John Thompson and Linda Thompson for Aaron Hernandez.
Good morning. Why don't we start with your motion to strike? I'll hear you on that.
Thank you, Judge Garsh. We move to strike two items. First of all, I'd like to address the supplement, the Commonwealth supplement that was filed on May 5th. We have several grounds for moving to strike that. First of all, it's outside the scope of the court's April 26th order, which permitted certain documents or certain submissions to be filed. Secondly, there's no request for permission to file additional papers here. Secondly, it appears that this is information, documentation that the Commonwealth had at the time that it filed its May 1st submission. There's no representation here that this is new material that wasn't available at the time the May 1st filing was made. But most importantly, the documents that are attached to the supplement are irrelevant to anything that faces the court here. Excuse me, that's raised either by the motion to abate ab initio or by the proper scope of a response. Since this is not an evidentiary proceeding, there's no place in the process here for these documents that are attached to the supplement. Much the same goes for the death certificate, which was attached to the Commonwealth's May 1st submission. The issue of Mr. Hernandez's death is undisputed. The only other information in the death certificate deals with the manner of death, which is irrelevant to the proceeding, to the issues that are presented by the motion for abatement ab initio, and that is made clear by the Luke ruling, which we cited in our memorandum, in which the Supreme Judicial Court last year dealt with precisely this manner of death and abated the conviction ab initio. So those are the reasons for our motion to strike, Judge, and we'd ask that it be granted.
Thank you. Mr. Bomber.
Good morning, Your Honor. Thank you. Your Honor, obviously, in handling a motion such as this, I think it is a requirement that the death certificate be before the court as proof of the occurrence. It's not just a death. As I believe Mr. Thompson was quoted, and I hope accurately, on the 19th of April, he himself announced that he had not intended to file a motion until receiving the death certificate. The motion was filed on April 20th, one day after Mr. Hernandez's death. The facts surrounding his death, the Commonwealth has contended in its filings, are relevant to the court's consideration. The material that was filed in the supplement, the Department of Correction report, was received on Friday morning in a public records release, Your Honor. The defendant's motion being filed on April 20th, one day after the defendant's death, while two investigations were ongoing into the facts and circumstances surrounding his death, which the Commonwealth contends are very relevant to the application of the abatement ab initio practice. That's why they've been filed, Your Honor. We filed that within essentially barely 2 weeks of the defendant's death. It's been timely filed.
Thank you. The motion to strike material submitted by the Commonwealth late is denied. Here on your motion to abate, and if you could stand at the podium, please.
Thank you, Judge Garsh. The doctrine of abatement ab initio is the doctrine that we're invoking here and asking the court to simply follow the law that the Supreme Judicial Court has set down. The cases, there are not many reported cases, but the ones that are reported disclose that this is an established common law doctrine that has been uniformly followed by the Supreme Judicial Court. It involves just two questions. Is there a pending direct appeal? And has the appellant died during the course of the pending direct appeal? Both of those facts are undisputed here. There are other issues that the Commonwealth has tried to raise, or has asserted, but excuse me, the reported cases and the Luke case make it clear that the issues that the Commonwealth has tried to present here are not relevant to the question of whether the prosecution should be abated ab initio in this case.
It doesn't appear that, or whether the Supreme Judicial Court has considered some of the issues raised by the Commonwealth, the ones with respect to suicide or forfeiture by wrongdoing. Is that correct?
It has not addressed forfeiture by wrongdoing. It has addressed death by suicide in the Luke case.
But in the Luke case, no argument was made to it, right, that suicide itself constitutes an exception, as opposed to the court should abandon the doctrine of abatement.
The information that we have in the Luke case, and in our memorandum we included a link to the Supreme Judicial Court docket,
right,
which contains just a docket entry.
But have you reviewed the brief that was filed by the Commonwealth in that case?
I have not.
Thank you.
No. I have actually, I spoke to the attorney who represented Mr. Luke, and my understanding is that that was the bone of contention in that case. To the extent that it involves an issue of a doctrine of excuse me, of waiver or forfeiture by wrongdoing, that involves questions of fact, at least to the extent it's very sketchily presented in the Commonwealth's memorandum. Our response to that is it is inconsistent with the doctrine of abatement ab initio, because as the Luke case indicates, the manner of death has never been a consideration in the SJC's application of this doctrine. The court has discussed, I think there are 4 cases. The Eisen case in 1975, the Harris case, the Latour case, and the Barrows case, all of which we cited in our memorandum. The court has said that there really is only one alternative that it has considered. And the reason for this is that the core interest here in the doctrine is in the finality of a conviction. And that's why abatement ab initio is limited to direct appeals. Direct appeals are an integral part of the finality calculus, that is, of the determination of guilt and of a fair trial. Those two are the two essential elements of a finalized conviction. Until a conviction has been finalized, when the defendant dies, either during after a trial and before an appeal, or during an appeal, the abatement ab initio doctrine applies without exception. The SJC has applied it without exception, and it has considered other arguments like those that the Commonwealth are suggesting here. For example, the importance of the issues in the case. The court has consistently said that is not enough of a consideration to change our practice. The interest of persons close to the other party, to the parties in the case. The court addressed that also in Harris and Eisen, and said that's not an important enough consideration to change our practice. So those two considerations cover most of the questions most of the issues that the Commonwealth has raised. And the third, the exception that they're urging of waiver or default by wrongdoing is one that has not been considered in a written opinion, but was considered and rejected in the Luke case. It is inconsistent with the doctrine of abatement ab initio. It has nothing to do with the narrow policy foundations of that doctrine, which is finality of the conviction. The conviction is not final. So the only circumstance in which a conviction has been allowed to stand after a defendant has appealed and dies during an appeal is when the appeal is not a direct appeal, when it is a collateral appeal and the defendant's conviction has already been finalized by a jury verdict or by a judgment of the Superior Court and by a direct review. The direct review is particularly important in first-degree murder cases because of the statute, Section 33E, which requires the SJC to review the conviction with particular care, without attention to technicalities, and to not only determine whether or not the defendant had a new trial, but to determine more generally whether justice was done, which includes determining whether the verdict was reached at an appropriate level by the jury. So the doctrine of, or a doctrine of waiver by wrongdoing does not exist in Massachusetts in general. There is, in the context, say, of the right to confront and cross-examine a witness, a intra-trial doctrine, that is, you can lose a trial right. A defendant can lose a trial right that the defendant has taken advantage of by making a witness unavailable. That's not a generalized doctrine in Massachusetts. It's just a doctrine attached to the right of confrontation. It's an exception to the right of confrontation. The right of confrontation.
So if you sort of hide away a witness, you can't complain.
If you kill the witness, or if you chase the witness off, if you intimidate the witness, then the witness's prior testimony is brought in. You don't have the opportunity to cross-examine it. That's something that the defense has brought about on itself. That is not a doctrine that has been applied to as an exception to abatement ab initio, and it is inconsistent with abatement ab initio. That's why it can't be, it's not a doctrine that can be created or recognized for the first time in a trial court. Under the Vasquez case, excuse me. Under the Vasquez case, this court is bound to apply the Supreme Judicial Court's constitutional rules and common law rules. And the way the Supreme Judicial Court has applied abatement ab initio so categorically, it would be inconsistent with the doctrine and practice of abatement ab initio to say, well, you can default that by the manner of death. You can lose the benefit of that doctrine, or that doctrine doesn't apply because of the manner in which the defendant died. The doctrine is less for the benefit of the defendant than it is for the benefit of the system. It is a way that the Supreme Judicial Court has decided to figure out how to terminate a case that has not
reached finality because of the defendant's death. And those are really the only considerations that the court has taken into account and put into play and vindicated by applying this abatement ab initio doctrine or practice. It's applied uniformly when the defendant dies in the course of a direct appeal, and there really hasn't been any other consideration. There's been a little discussion of the possibility that the court might go ahead and decide a case that has already been briefed and argued, but it's never done that, except in the Squires case this past February, which was not a direct appeal. In the Squires case, the defendants had had a direct appeal. Their convictions had been reversed. Their convictions had been upheld in the appeals court, and they applied for further appellate review, and one of them died after further appellate review was granted, but before the decision had been made. And the court went ahead and decided the issue, I think, for two reasons. One was because it needed to consider the arguments that the dead appellant had made.
Excuse me for a moment. Those in the back of the room, please, if you want to leave, you can leave. It's an open court. You can walk in and out, but what you can't do is talk while you're in this courtroom. Thank you. Sorry to interrupt you.
The defendant who had died was the one who had made the key arguments on the issue that the Supreme Judicial Court decided to go ahead and answer, which was whether the evidence was sufficient to support the conviction, and they determined that it was not. So this was a case where, first of all, it was not a direct appeal, it was a collateral appeal, and so abatement was not the issue. The issue was whether the collateral appeal would be dismissed, and the answer was no, because the interests of justice require that we set aside this conviction that's invalid and that we treat both defendants the same. So the Supreme Judicial Court has not left any open questions about when this doctrine applies and how it is to be applied, and whether there are exceptions, or whether there could be exceptions, or whether there are policy judgments to be made in applying it. The policy judgments that underlie the doctrine have been made by the Supreme Judicial Court. They've been applied directly, uniformly, without exception, at least since 1975 in the Eisen case. And so there is no room in the framework for the arguments that the Commonwealth is making.
Thank you very much.
May I, Your Honor?
You may.
Thank you. Mr. Thompson tells the court that waiver or forfeiture is based on the premise that something the defense has brought about on himself operates to cut off what would otherwise, in some circumstances, be constitutionally protected rights. And he suggests that those are only intra-trial rights, but those are constitutional rights, Your Honor. The defendant here suggests that that general principle has no application to something that is not a constitutional right. There is no constitutional right to abatement. There's no constitutional premise to abatement. Something that's not a statutory right. There's no statutory basis to abatement. It's not a rule of criminal procedure promulgated and written by the court and subject to discussion amongst committees. It is a practice. That's what abatement is. And I'm going to suggest to the court that our law follows the procedure of forfeiture, or provides for forfeiture of far more protected rights allows for waiver, provides for waiver of far more protected rights because of the fact that a criminal defendant has unclean hands in the circumstances. That's what's required to find a forfeiture.
Are you aware of any case anywhere in the country that's still good law that applies a waiver or forfeiture to the abatement issue?
It's been the subject of a lot of discussion, I know, as the court would follow, but there is no final outcome that says that is then the standard. But what it has done.
Any case anywhere where any court has so ruled and the decision has not been vacated or reversed?
No, Your Honor, but what's happened is that then the courts, in consideration of that line of cases, have come to the fact that they just don't then apply abatement. So, for instance, in Wisconsin, in ultimately reviewing the issue of the suicide, what the court finally concluded is that they would no longer apply abatement. That it's difficult for the court ultimately to make these distinctions. And so our argument is sort of on a number of levels. You could have forfeiture of the abatement ab initio doctrine alone, meaning you're just not entitled to abatement. Or you could have forfeiture of your appeal. So it's not to suggest that the wrongdoing has to ultimately be a forfeiture of an appeal right. It's to suggest that there is no reason ultimately to apply abatement in these circumstances. Now, you can look at it, I suggest to the court, in two ways. The court, I have the Luke Commonwealth's filing. It does not raise the issue that the defendant raises.
But it does raise the issues in the first half of your brief. It does raise the issues.
Correct.
And is there some reason that Luke wasn't brought to the court's attention? I mean, it raises precisely those issues. And the SJC, within a year, less than a year ago, said we've considered those issues and don't find them persuasive. They had some of the same cases that are cited here, the same argument that it should be abandoned, that the modern trend is to change abatement. But you're making that argument.
Well, our argument is, Your Honor, to show what is the basis of the abatement doctrine, because ultimately the court has repeatedly said it in the cases that the defendant cites. We've asked the parties to explain to us why we shouldn't apply abatement, our general practice or our long-standing practice in this case. And part of understanding why abatement should be applied in this case or not applied in this case is what is the basis of abatement. The fact that it is a trend away from abatement. That some of the reasons that the court has announced in other cases, there are really only two cases where the court analyzes abatement at all. I suggest to the court Eisen, which is sort of the modern pronouncement, that's where we go back to here, and the De La Zerta case, which, notwithstanding the fact that it has this sort of collateral review issue, stands for essentially the proposition of abatement. It's cited in lieu order, right, which is just an order in the docket. It's cited in the defendant's own filing. So it is, notwithstanding it's not a technical abatement direct appeal case, it is an abatement case. It's talking about abatement. That's probably the best understanding of abatement that we have in the Commonwealth. And so what we're trying to say in our filing, Your Honor, is if you look at abatement, the court has repeatedly said, well, we'll entertain what the parties say of why we should or why we shouldn't apply abatement in this case. And in order for us to say that you shouldn't, we have to identify what the principles are as we see them, as the court has announced them. And as the court said in De La Zerta, we will not apply it in special circumstances. Right? And so here, our case is different from the Luke case. That's the Commonwealth's contention, that this is not a defendant who has arrived at the killing of himself by happenstance. That's not what the evidence shows. That's not the result of the investigation. And so when this defendant takes his own life, He's indicated he understands what the theory or the practice of abatement is. He's indicated
he's heard a rumor.
right, but that it exists, Your Honor. I mean, in the circumstances, that's where we're at. And that his taking of his own life is a purposeful act. It's a conscious and voluntary act.
And that wasn't true in Luke?
I'm not suggesting that, but we are providing the court that evidence, and that there is a reason, a motive for the defendant to have done it. That, I'm suggesting to the court, separates this case from Luke. There was no proffer of any of those things made in Luke. So as a factual circumstance, it's the Commonwealth's contention that the case is different than Luke. And so there are two ways, I think, from the Commonwealth's perspective, the court can look at it. The practice of abatement as pronounced by our court and the purposes that it serves is open, as the court has repeatedly said, to arguments of the parties why it shouldn't be applied. That is the special circumstances or interest of justice, as the court found in Squires, right? So the abatement doctrine by itself is not reflexive, it's not necessary, it's not absolute. That's the Commonwealth's contention in reading the cases. And so the court, in the circumstances we find here, consistent with the existing abatement doctrine, in service of its purpose, could find that the abatement ab initio practice doesn't apply. Or the court, consistent with our common law practices, could find that this defendant, in his conduct, has waived or forfeited his rights. Now, again, as I indicated to the court, there would be a sort of strong forfeiture or a weak forfeiture possibility. It is not at all necessary for the court to say that he has waived his appeal now in order to decline the defendant's motion or deny the defendant's motion. But I would bring to the court's attention, as the defendant points out in his response, the purposes that are protected by appeal or that convictions be subject to review on appeal, and particularly the defendant cites 33E review. There are a couple of things. One, it's possible to have a first-degree conviction that is not subject to review and is a final conviction. In this court, a defendant by the name of Gary Gomes pled guilty to first-degree murder. That, according to our law, would be subject to automatic entry into the SJC. Mr. Gomes did not have an appeal. He pled guilty. And I know that's a distinction, Your Honor, and I'm not suggesting that this is the be-all and end-all of the issue. But what I'm saying is that the court is comfortable in circumstances where there is no final review of first-degree murder convictions. Gary Gomes pled guilty to murder. His conviction was never subject to any review. Michael Kelly, in a Plymouth case, pled guilty to murder. His conviction was never subject to any review. I've looked at the SJC dockets in their names. They continue to be held in the state's prison. So that, in and of itself, can't be the whole purpose, right? We know that every day people are convicted. They have a right to appeal. Some take it, some don't. Now, this is a little different, and I understand that, Your Honor. I'm not suggesting that proposition stands for the defendant has no right of review. I'm not suggesting that. But what I'm suggesting is you can see, in our view, that there's a difference between abating a conviction. This is a defendant who's not presumed innocent. We have a return of a jury verdict after an extensive trial. And after a complete review of the trial record at the defendant's request. As you'll recall, Your Honor, on May 7th of 2015, Mr. Hernandez filed a motion renewing his motion for required finding and seeking review of his conviction by you, Your Honor, on 25B2, asking for a reduction of his conviction to a conviction in the second degree. As the court says in the Woodward case, 25B2 review is the same, similar, is the exercise of the same power as 33E review. That was done on June 25th, the court entered an order denying the defendant's motion, denying the defendant's motion to set aside the verdict, the renewal of his required finding of not guilty motion. And with respect to his 25B2 portion of his motion, the court determined the verdict rendered by the jury is consonant with justice. That, Your Honor, is a defendant who is no longer presumed innocent. And what he's asking the court to do by application of this abatement ab initio doctrine is return him to the presumption of innocence. And the Commonwealth's position, Your Honor, is that the defendant should not be able to accomplish in death what he could not accomplish in life. That the defendant, in his purposeful act, calculated as it was in the circumstances that we find ourselves, should not be entitled to abatement ab initio in this case. We'd ask you to deny the defendant's motion.
Thank you very much. Did you want to respond?
If I may.
You may.
I find myself a little bit sandbagged by facing arguments that weren't raised in the papers, which is ordinarily the purpose of filing before argument. But I would point this out. First of all, on the question of a waiver or default, the record doesn't come anywhere near establishing the broad argument that the Commonwealth makes. And if the court is going to entertain the possibility of applying that kind of a doctrine in this case, in these circumstances, there's going to have to be an evidentiary hearing. There's been a few submissions suggested that offered that suggest that there was that this death was by suicide. There certainly is some evidence of that, but there's been no adjudication of that proposition. There have been at least 2 investigations, and there's, I believe, the Worcester District Attorney's Office is also conducting an investigation. So the state police have conducted an investigation and issued a 132-page report, out of which the Commonwealth has submitted a few pages. The medical examiner has conducted an autopsy and issued a death certificate, but the bulk of the documentation that the medical examiner's office generates has not been disclosed to us and hasn't been presented to this court. The Worcester District Attorney's Office is conducting an investigation. We're not privy to the status of that investigation, certainly haven't seen any report. But there's a lot of evidence to be considered in determining whether or not Mr. Hernandez killed himself. And if so, the second proposition is that he did it for the express purpose of invoking of taking the advantage of the doctrine of abatement ab initio. The evidence suggesting that is a second or third level hearsay report by an unnamed inmate. The report is made by an inner perimeter security official whose business is to operate, among other things, the informant system within the prison. So we could say that this is probably the report of an informant, unidentified, who happened to say almost exactly what some official wanted to hear. Not the most reliable proffer that one could imagine. We have evidence to the contrary that we could submit if this was an issue to be decided in this case, but it clearly is not. The suggestion that the trial court's 25B2 review is equivalent to the Supreme Judicial Court's 33E review, I would respectfully suggest this court is a highly regarded judge, and I would not say anything to disparage in any way the work that this court put into this case. It's well known. But it's not a review by the Supreme Judicial Court. It wasn't a direct appeal. And the Supreme Judicial Court has not invited on a case-by-case basis the parties to suggest alternative policy grounds or reasons why it ought to change its practices. Parties have proposed, parties have argued, as the Commonwealth is here, and the Supreme Judicial Court has consistently said no. No, this is not a reason for us to deviate from, whether you call it a practice, this common law rule. It is the rule that applies to this case. Abatement ab initio applies when the appellant has died during the direct appeal. That's the situation that we have here. The manner of death has been considered in other cases. It hasn't altered the practice. The policies, the court has, whether it has endorsed them with ringing enthusiasm or with some form of reluctance or hesitation, it has nevertheless, every time it's considered the issue, adhered to the practice. The De La Zerta case is probably the best example of what this case is not. In De La Zerta, the Supreme Judicial Court said, if you'll excuse me for a moment, I believe it's in our memorandum, our reply. The question here is whether to treat this as a direct appeal to be abated ab initio or as a collateral appeal to be dismissed. That's the two categories of action that the court considers when an appellant dies during an appeal. If it's a direct appeal, it's abated ab initio, period. If it's a collateral appeal, it's dismissed. And the conviction stands because it has already been subject to direct review, and that's what makes it final. This is not a final conviction. If the 25B2 review was the equivalent of a 33E review, there would be no appeal here. There would be an application to the gatekeeper under 33E. So this is not, although it has been reviewed by this court, this is not a final conviction, and that's what matters.
Thank you. I have had the benefit of the briefs for several days, so I've had the opportunity, which I have taken, to read all of the cases and to consider all of the arguments. So I'm going to take about a 20-minute recess at this time, consider your summary of your arguments that you've made today, and expect to come back out and issue an oral decision and follow up with a written decision most likely later today. So we'll take about a 20-minute recess.
Court, all rise.
Thank you.
Court, all rise. Good morning. The court is now in session. You may be seated, please.
The long-standing rule in Massachusetts is that if a defendant dies while his conviction is on direct appeal, the conviction is vacated and the indictment dismissed, thus abating the entire prosecution as if it never happened. Many other states and the federal courts follow this same practice. The Commonwealth has argued that the abatement doctrine, quote, lacks any identifiable historical or public policy basis. To the contrary, abatement has been practiced in federal and state courts for more than a century, and the Supreme Judicial Court has explained that the primary policy served by abatement is the recognition that because an appeal is an integral part of the system for fairly adjudicating guilt or innocence, the interests of justice do not permit a defendant to stand convicted without resolution of the merits of his appeal. The Commonwealth is incorrect that the United States Supreme Court has rejected the policy of abatement in Dove versus United States. That case merely held that when a defendant dies after filing a discretionary certiorari petition, the Supreme Court dismisses the petition but leaves the underlying judgment untouched. Nothing in the two-sentence decision suggests that the Supreme Court was rejecting the policy of abatement should a defendant die during his direct appeal. And post-Dove, there are cases from all of the circuit courts that have abated not only the appeal, but the prosecution from its inception in cases of a defendant's death pending direct review. The Commonwealth argued in its brief that this court should follow an emerging trend in some other states to reject abatement in order to respect jury verdicts and protect the rights of victims and their families. What the Commonwealth did not mention in its brief was the fact that the Supreme Court considered and rejected the identical public policy arguments less than 1 year ago in Commonwealth versus Keith Luke. The court at that time stated in its order, nothing in the Commonwealth's submission persuades us to change our long-standing practice in these circumstances. Abatement remains the law in this Commonwealth, and this court is compelled to follow binding precedent. There may, however, be situations where the interests of justice merit a departure from the practice of abatement ab initio. The Commonwealth argues that waiver and forfeiture principles warrant an exception to abatement when the defendant commits suicide. This was not argued in Commonwealth versus Luke. Waiver is the intentional and voluntary relinquishment of a known statutory or constitutional right which can be inferred from a person's words and conduct under all the circumstances. Forfeiture by wrongdoing is based on the principle that a defendant should not be permitted to gain a tactical advantage from his own wrong. It requires a specific intent by the defendant to interfere with the course of justice. The Commonwealth maintains that Hernandez deliberately and voluntarily acted to end his life, and that such conduct manifests an intention to abandon his filed appeal. In support of that proposition in its filing, the Commonwealth relied on 3 cases, each of which has been vacated or reversed. In Dwyer, the defendant, an attorney, committed suicide before sentencing, stating in his suicide note that he had no faith in the judicial system. He also has stated that he did not believe he could succeed in reversing the verdict upon appeal. Here, by contrast, an appeal was filed. Chin also is factually quite distinguishable. In that case, the defendant committed suicide again before judgment entered. Nothing in the record of that case supported a conclusion that counsel for the defendant had either been requested or authorized to take an appeal. Indeed, the record in Chin justified a conclusion that the defendant did not intend to appeal because he wrote to his wife that he had decided not to appeal and that his decision had made him feel extremely tranquil. The Wisconsin Court of Appeals in McDonald did hold that suicide after filing a notice of appeal justifies an exception to abatement, but that decision was reversed by the Wisconsin Supreme Court. This court cannot know why Hernandez chose to end his life. I decline to infer an intent by Hernandez to relinquish his appellate rights or an intent to interfere with the course of justice from his suicide, a tragic act that may have complex and myriad causes. The Commonwealth supplemental filing suggests many possible motives for suicide, unrelated to the defendant's appeal. The report contained in that supplemental filing, which is a series of statements purportedly made by unnamed inmates. Particularly telling is the fact that, according to the Department of Corrections investigatory report, inmates were aware of, and some viewed as disrespectful, a radio broadcast that, quote, brought up the fact that Hernandez may be gay. The report also states that, according to other inmates, Hernandez had become increasingly spiritual while in prison, and they viewed his suicide as some sort of religious message. One inmate stated that Hernandez frequently talked with a religious tone and expressed his belief that when you die, your soul gets reincarnated. A religious motive and possible mental disturbance is reflected in the note Hernandez allegedly left for his fiancée, in which he wrote, "This was the Supreme's, the Almighty's plan, not mine." The report states that an inmate who claimed to be one of Hernandez's best friends said that after the verdict in the other case, Hernandez had been talking about the NFL and going back to play, even if it wasn't with the Pats. Statements that do not reflect the mindset of a defendant who intended to waive his right of appeal. While the report does state that Hernandez had recently mentioned to one inmate a rumor that if an inmate has an open appeal and dies in prison, he is acquitted of the charge and deemed not guilty, there is no indication that he had been so advised by any attorney. The mere awareness of such a rumor hardly is sufficient to warrant the inference the Commonwealth seeks to draw with respect to the defendant's specific intent. In any event, this court could not draw the inferences suggested by the Commonwealth as proof of intent or forfeiture, proof of waiver or forfeiture, without holding an evidentiary hearing as to the manner of death, should that be contested, and the facts that bear on waiver or forfeiture. A court should not have to conduct an exhaustive examination in every case as to the circumstances of a defendant's death to determine if it actually was suicide, if the defendant had the capacity to make a voluntary choice whether or not to live, and the factors or factor that motivated the suicide. The interests of justice, I conclude, do not warrant a departure from the doctrine of abatement under the theory that suicide constitutes waiver of the right to appeal, or the theory that suicide constitutes forfeiture by wrongdoing. Finally, the Commonwealth argued in its brief that the interests of justice warrant not abating Hernandez's convictions on the grounds that he had a negligible probability of success on appeal. None of the Massachusetts cases discussing abatement hint that the merits of the appeal might be relevant. In any event, Hernandez did not yet file a motion for new trial or appellate briefs before his death, and this court cannot speculate as to the potential grounds he may have raised to challenge his convictions. Accordingly, there being no reason to recognize any exception in this case in the interests of justice, the court has no choice but to abate the proceedings ab initio by vacating Hernandez's convictions and dismissing the charges against him and his appeal. Mr. Bomberg, with respect to the open cases of unlawful possession of a rifle without a firearm identification card, unlawful possession of a large capacity weapon or large capacity feeding device, unlawful possession of ammunition, assault and battery, and threats, does the Commonwealth intend to file in those cases a motion to dismiss?
Yes, Your Honor.
Thank you. Can you do that sort of relatively shortly?
I can. I believe that his counsel of record remains Mr. Fee at this point, but
Right.
I'm not 100% certain.
Right, but the Commonwealth can file that with the death certificate, so it's in the relevant cases, and then you can give notice. Mr. Fee, I believe, is still counsel of record.
Yeah, I'll send you a notice.
Thank you. Thank you very much.
All rise, please.